Good afternoon. Because of obvious events, maybe it's best to come out anonymous. Maybe. It might be safer to do this video if I'm anonymous. Maybe. But I guess we won't do it that way. And we'll do it the normal way, straight up, if that's normal. Black hat and all. Not legal advice. Please like, subscribe, share, comment, whatever else you can think of. Appreciate anybody who watches this. Anybody who wants to comment, feel free. You notice I've moved from the snow to space now. Welcome out here. Beautiful view you could see. So kind of what I wanted to talk about is the legal proceedings involving GTII and maybe some of my own stuff related to that, and bringing up to speed as to current, very current. Of course, that is the idea, and I'll do that for you in a second. Of course, just a couple of points. What do landscapers invest in? Hedge funds, of course. Las Vegas is the place where your wallet goes to go onto a diet. By the way, I was in Las Vegas yesterday, related to this, and it was 120 degrees. 120. It's pretty warm. Oh, that's funny. In Vegas, the only thing tighter than the slots are your pants after the completion of a buffet. I'm sure you all can get that. Anyway, so what I'm going to do is first go into the current status of GTII. I'm going to reference Alpine really quickly, and then I'm going to go into the complaints. I'm going to compare and contrast, so we'll have a little fun. Maybe anybody who wants to hear about it. So Alpine, quickly about Alpine. So the attorneys for FINRA, so this is referring to the appeal in DC related to the Alpine. It makes me crack up every time I say expedited. Alpine's, the expedited proceeding against Alpine to kick them out in DC. That's on appeal. And it's been sitting about 3 months now post the conclusion of the oral arguments. And yes, the 8th, July 8th, when that would have been, yeah, that would have been yesterday. There was a letter filed by FINRA giving some additional authorities. So they cited additional cases and statutes, etc., in support of their position. This involved a new case that had been recently decided in that circuit. They said basically it's a private company, therefore you're not entitled to constitutional protections. That's the summary of it. But it was just submitted, and it's already 3 months after the oral argument. So they submitted it, and they get away with it because it would be new facts, considered to be new, so you could do it. Otherwise, you wouldn't have been able to submit it. But anyway, it was just submitted, so I don't know if that will extend the period of time in which it'll take the court to rule in Alpine or otherwise. We shall see. And the other, as far as I know, the other proceeding in Utah or Arizona is on a stay, and it may be stayed for some period. I don't know, because we don't really know how the SEC works and what they do. So that's that. Now talking about GTII. So GTII, so just kind of refresh everybody's recollection. I happened to file a complaint some time ago. Sometime after that, in I think it's late June, on behalf of approximately 250 shareholders, an action was filed in Nevada, and it named a bunch of the directors. And GTI is located in Nevada, and that's why the relevance of that. I guess, yeah, so it named directors Reichman, Griffin, Benintendo, Gilbert, and it named GTII as a nominal defendant because they're a party, but they're not really at risk, let's say, in this complaint, because this would be, in essence, a derivative action for the benefit of the company. Anyway, that action was filed, a verified complaint was filed with 250 plaintiffs, approximately. and it asserted a bunch of claims. And after it was, and it also asked for the appointment of a receiver. And it's filed June 27th, 2024. After it was filed, the intention, oh, let me back up. So after it was filed, a judge was assigned. They, for whatever reason, they didn't feel comfortable with that judge. So I think, as I mentioned this before, in most jurisdictions, you have one free opportunity to get rid of a judge without cause being an issue, and you're allowed to do that. So they did that. Another judge was assigned. They served notice, including the complaint and of a proceeding to go in and have a receiver appointed and to get an injunction. Post that, the GTII crew went in and they affidavit. They objected to the judge that had been chosen as a secondary judge. And before a third judge was nominated, and in this business court, there are 5 judges. They also filed, so perhaps, I don't know if they, when they said they were objecting to the judge, maybe they were doing it to buy time to do something else. But then they sought to remove the case to federal court in Nevada. So what's removal? If you're in a state court action under certain rules, you can take that state court action to federal court. Now, what's one common way of doing that? If all the defendants and all the plaintiffs are from different states. And if that's the case, then something called diversity jurisdiction exists, and you could file an action in federal court. So they removed it to federal court. They filed a notice of removal. Upon it, and I'm telling you everything that's been discussed between them. I'm not going to tell you detail, but so this has all been discussed. So it's not involving future strategy or future whatever. It's on the table. So I'm not telling you anything that the parties and the attorneys don't know. So after they asked to have it removed to federal court, and you literally file something, so it's going to go, and then you have to undo it to stop it. So after they did that, and this is all happening in the last few days, this happened very quickly. After they did that, the attorneys that we're working with for us, they looked at it and they saw, well, oops, there are a bunch of plaintiffs that cross and come from the same state as the party that they were referencing. And I don't remember which state. It's an East Coast state. So, whatever. Joe is, and I'm just making it up, Joe's from New York, and it happens to be a bunch of plaintiffs in New York. And if that's the case, then you have no diversity jurisdiction. And that apparently is the only way they have asserted jurisdiction. So there's been a request made in some fashion to agree to send the case back to state court. And I don't think there's been a final determination about that. If, in fact, they don't agree to that, then there'll probably be some kind of a filing seeking the return back to state court. And even though the federal court would be fine, it's probably easier and maybe quicker in a state court, perhaps. It really depends on the circumstances. But that's where the case started, so that's where they want to go back to. So we will see what happens. I expect there to be movement one way or the other in the next day in terms of whether there's an agreement to put the case back in state court and then proceed that way, or if there's a motion filed in the federal court to remove it back to state court. But either way, something's going to happen. And this is moving pretty fast because the complaint was filed again June 27th, and there's been one court appearance, but there was nothing happened because a new judge hadn't been selected. But there's been a bunch of paperwork that's been filed, obviously. And I would expect a determination about where it's going to be or what's going to happen next within the next day or two, which I obviously shall report on. So case has been filed, it's proceeding, and we haven't had a hearing yet on the receiver request or the request for the TRO, but in some form or fashion, it will be coming shortly. Just question is it going to be in state court? Is it going to be in federal court? And we shall see. So that's up to the date. today as of July 9th. Now, so that's the procedural status that is literally up to the minute. And if I told you they filed a complaint, the complaint was 28 pages long. That's the complaint that was filed on behalf of shareholders against the directors in Nevada. Now, if you all know, I was sued on or about July 2nd by GTII and David Reichman. Oh, that's fun. And they sued me in federal court. Now, there might be an issue as to how they got to federal court, whatever. And if you know, I had a problem because I had an issue with they sent a letter to me at my house. They personally served me at 6:30 in the morning on a Sunday morning after having emailed me a copy of the letter which I received. But they did it, so it annoyed me to say the least. So I agreed to I agreed to waive service, which in essence, once they've provided me the form, means they don't have to come out and find me, and I have 60 days to respond. We had a communication today, and they said they had to amend the summons. I don't know what specifically they had to do, but they were amending the summons, and then they were going to send me the paperwork so we could do the waiver. After I sign the waiver and that's all done, I'll have some further discussions about kind of procedural stuff and what I intend to do. But what I thought might be an interesting exercise, and it's all covered by privilege now because these are public complaints, and so they are able to be discussed. And I presume that the complaint against me is at least was intended to be accurate. There are a bunch of issues, but I'm sure it was intended to be accurate. We know we have a complaint in Nevada, and both are public, so whatever. So I thought it would be interesting to see, because the claims against me are for defamation and trade libel. Defamation being, saying something that's inaccurate, causes harm, that's intended to do harm. Trade libel is somehow impacting the name of the company. But anyway, those are the claims. But what they are based on, in part, it's on page 4 of the complaint, if you get it, starting with line 17, paragraph 17. It's a bunch of statements that are made in this document, and they accuse me of making those statements. And I don't even know if the statements are made because I haven't looked, honestly, I've not gone back and looked, and I don't know the context of them. For example, they might be citing a YouTube video. It could be 4 seconds of a video, literally, and the words prior could be conditional, but they're not here. So I don't know the accuracy of the statements. I was just going to deal with what they claim the statements to be, and then look at the complaint that was filed in Nevada and see if any of those are addressed in a way like that. And this is just kind of looking at the public documents. So this is not even, obviously, I had personal communications and involvement with GTII and management. So I would have my own position and recollections, whatever. And I think I've mentioned I had, probably sent 100 emails, had communication with Mr. Fattel, had one telephone call with the current COO, no response from anybody else at GTII, no management response. And I verified that they were all receiving information, because I just wanted to be careful that no one would make that claim before, even though nothing ever bounced back. But on one occasion, I sent an email to 2 directors only, and I got a call back or an email back like 2 minutes later from the attorney. So I knew there was a little bit of a triangle going on, and that everybody knew what was going on. So I felt comfortable about that. So I kind of wanted to look at, and we'll call these out. And with the reservation, I don't know if these statements are accurate. I don't know the context. And if it's like, you can imagine, here we are. So let's say we do a 20-minute, 30-minute live stream. Within a 30-minute live stream, notwithstanding the issues, because there's a bunch of other issues, like is it opinion? It's an opinion or a fact. Is it covered by some privilege? Is it covered by some other principle? Is it true? All that stuff, intent, because clearly my intent, it's interesting, my intent clearly here is for the benefit of all shareholders and for the ultimate benefit of GTII. That's been my interest throughout. And also, obviously, by the title of my channel, this is legal, not financial. So to the extent anybody contends that what I'm providing somehow is financial advice, it's not even legal advice, and that's why the channel's name. So, and by the way, those are issues that will come up. So, again, what I want to do is go through the statements and see if I could find something in the other complaint that deals with it, and then at some future point in time, I will more in depth deal with this. But this is in their complaint. They filed. I don't know why they filed it as they did, but they did. So I'm at paragraph 17A. GTI management diluted, stole, and or misappropriated money from GTII. Then it gives me a citation, but again, I don't know where it is, and I'm not going to go, look at about 50 videos and look at the entirety of it. But just look at the statement. And I'm sure they wanted us to talk about the statement and have a good understanding of what they're claiming. So GTI management, that's kind of vague what that is, but let's assume it's true for the sake of this discussion. Diluted, stole, and or misappropriated money. So diluted would mean they might have, what's a way of dilution? Like issued stock, something like that. And so I recall in that complaint, if you recall, remember there was a paragraph. Oh, here it is. Happen to find it. How do you like that? There's a paragraph in here. And this is, what's interesting also is, so when I had a lot of interaction from February through April, I didn't know a lot of the stuff that's in the complaint. So what I was speculating and opining upon was more intuition and some stuff I had received, but a feeling and certain absence of information that gave me a gut feeling about certain stuff. And then when you look at the complaint that was filed in Nevada, it appears that my intuition was correct. So again, that 17A talks about dilute, I think it's diluting GTII. And we have all these shares that are issued to appears to be people that are close to Mr. Reichman or his foundations, if you recall. Like the one foundation, 21 million shares, to another foundation, 2 million shares. We know that he gave, remember that, 550,000 shares to his mechanic and 850,000 shares to his fantastic masseuse, a bunch of shares to an insider close family member, 3 million to a girlfriend. So could that be arguably dilutive to GTII? I guess it might be. Might be could you say that's misappropriating money from GTII? I guess you might be able to say that too, because you're diluting the if those are true. In paragraph, I'm reading from paragraph 36 of the Nevada complaint. That's where those in. And if that's true, and a bunch of shares appear to have been perhaps improperly provided to various people. I mean, again, I guess the masseuse was really good, but 850,000 shares, if true, that's a lot. That's what the complaint says. So arguably, if someone was looking at that, could they claim that that was dilutive or stole? I mean, it's not a great English here, by the way, or misappropriated money. So I would say dilutive, sure, and it says or, so I guess it only has to be one of the three, I would say. And if it's one out of three, and I think there's a bunch of shares that suggest dilution, and then we know also they issued about 70 million shares. I remember this, January 25th of 2023, and they recently had to cancel 36 million approximately. because they were erroneously or inadvertently issued. I guess, again, they must have pushed the wrong button and the stock certificates just flew out. But if they erroneously or inadvertently issued 36 million shares, perhaps someone might say that was misappropriation or dilution, certainly improper. And it only has to be one of those three. So it makes you wonder. And then if there's any more confusion about that, we're just using the first one, by the way. Maybe we're going to do a couple of these because I probably could do this to all of them. And this is just one aspect of the analysis, by the way. But we look at paragraph 37 of the complaint, and it says, do you remember that what it said? And I'll just summarize. There's a transaction involving apparently the general counsel or the company's counsel for GTII, who brings this deal in some entity to GTII. GTII apparently gives 10 million shares. The entity sells the 10 million shares, and the proceeds, which happen to be $2 million, were split between Mr. Reichman and apparently the counsel. Some people might consider that, I think, stealing, misappropriation. Some people might consider that. I mean, I consider that. But if I look at that, that's certainly breach of fiduciary duty. It looks like to me, looks like it's kind of backdoor, sleazy. Just doesn't look like it's a proper transaction, because it looks like just what it looks like as alleged. It looks like maybe you kind of set up something just to generate cash out of thin air, because that's what it almost looks like. And if that is true, and when I was thinking about this, I don't remember the precise thing, but what occurs to me was that in the 10K, if you looked at it, and I did look at it, and since this is the date reflected here is after the 10K, the cash, the absence of the cash, in other words, in the 2023 compared to 2022, there was a significant amount of cash that had disappeared or seemingly had disappeared. There was no note explaining it. And in all my emails to various people at GTII, they never responded to that, explained it, etc. I thought it was pretty serious. And in light of the fact not responding to it, what else could you believe? And I know it's also referenced in the Nevada complaint. So in addition to what I just said about that $2 million, the cash, and I think they allege is like $4.3 million, seemingly disappeared. So if someone says that maybe what happened to the cash, and then the person doesn't respond, and then you see cash has disappeared or is not accounted for, what else are you supposed to conclude? But that was just one of three items. Remember, the statement reflected in the complaint filed was GTI management diluted, stole, and or misappropriated money from GTII. So again, it only has to be one of those three because it's an or. And I don't know if that's even accurate, but we're just talking about it. So we've spoken about the complaint, not just other things, but the complaint. I guess I referenced the 10K. That's another fact. But I'm just trying to stick with the complaint. We've referenced the complaint, the distribution of shares, including apparently to the mechanic and to the masseuse, M&M, as we like to call it, the $2 million. And then there's another reference on page 38 of the paragraph 38 of the complaint in Nevada, page 13 of that complaint, that talks about there were certain transactions that were settled and money didn't come back to the company. Instead, it went to Mr. Reichman's trust. So again, I don't know if that's true, but that's the allegation. And if that's true, some people might call that self-dealing, inappropriate. They might interpret that as being dilutive, or might say it's misappropriation. The money should have come to the company, then arguably it certainly could be misappropriation. And that's, again, in addition to the 2 million we just mentioned, these transactions, the 4 million, and even one of the paragraph 39 says I made demands on management to correct the action, and they refused to comply with the demands. It's in the complaint. It's the Nevada complaint. So we have the allegation again 17A, and there's a bunch of these. And this is more, for example, GTII management diluted, stole, and or misappropriated money from GTII. So we've gone to the complaint. We've talked about the share distributions. We talked about the settlement money. We talked about the 10K and the 4 million in cash, and a lack of explanation as to that. And we know they used a auditor that was a scam auditor, Borgers, who got terminated by the SEC. So I think that probably does justify some questions. Then on top of that, so still dealing with just that first paragraph, which says that GTII management diluted, stole, and or misappropriated money from GTII. That's 17A. There's also a section of the Nevada complaint that deals with self-dealing, conversion, and waste, and it talks about the loss that's referenced in the 10K, and I certainly reference this, that how zero revenue, but you go from on 1 year in 2022, and again, without explanation, and using the scam auditor, Borgers, in 2022, you have a net operating loss of 13.1 million, and in 2023, somehow, your loss is $83 million. That's six plus times 600%. 600% increase, zero revenue, no explanation. Again, that's the problem is I didn't see in any of these discussions any explanation as to what really was going on, because obviously I would have preferred to get an explanation that made sense, that made everybody happy, that suggested all things were good, everything was going to move forward. But no. And I think I asked, my recollection is in one of my emails, I did ask about that, for example, about the increase in the loss and with no revenue, along with the issue about the cash. So that's another thing that's referenced in here. I think that would also be relevant to the statement that GTI management diluted, stole, and or misappropriated money from GTI, that these plaintiffs claim that I said, even though, again, I don't know that's what was said, and I don't know the context. I don't know, and everything I'm saying obviously is opinion. It's not like that's complicated. It's obvious. I think that somebody's trying to be abusive? Of course I do. That's my opinion. Of course, they're being abusive by having to proceed this way and giving me this and making me have to kind of point out things in the complaint. I guess they don't care about the content of their own complaint, but be that as it may. The other thing that caught my eye in the complaint. So now I'm talking about Nevada complaint dealing with that first section, dilution, stole, or misappropriated. If you look at paragraph 47 of the complaint, it talks about the issuance of like 65 million shares on January 25th with a value of about $98 million. I think that is a dilutive event, and that is referenced in the 10K does reference the share problems, and they are a problem. It is, and it was such a problem they had to cancel a portion of those shares in June of 2024. So it's not just they issued them, but they erroneously or inadvertently issued them. So would someone say that created a dilutive issue with GTII? I think somebody would say that. So that's just another example, and the fact they had to cancel the shares is just an alternative. So let me go to the next one, and I'll just show this to you how this would play out. I'll just use that first one just to give you an idea, and that doesn't deal also with all the communications I might have had. There are other legal defenses and legal issues. B, as they've asserted here, and again, I don't know if it's true, I don't know the context in the statement, they have quotation marks around a portion of a sentence. So it says GTI management. And by the way, the prior one did not have a quotation marks. So I don't know what came before it or what comes after it. I don't know if it's accurate. I don't know why the other things don't have quotation marks around it. Does that mean they are not a quotation? Does that mean this is the only quotation? I don't quite know, but it says GTI management looted the blank out of this company. I don't know if did I say the blank? That's interesting if I did. Yeah, in my opinion, if I stated it, that would have been my opinion, and it's dated May 14th. I would have had all this information under my wings. I would have had the 10K that showed the share distribution. I would have known about the distribution of all the shares. I would have known everything else. So, in my opinion, when they issue shares to everybody and their mother, is that looting? For me, in my mind, that would be looting. Again, I give them that's just my opinion. But without explanation, if you accuse somebody of something and they don't respond, what else can you presume? Especially when you have a 10K that gives you the information, when you receive information of all sorts from various sources. I don't understand. Whatever. If true, the same facts we just discussed that were in the complaint about the distribution of shares. We talked about the claim about giving shares to the M&M team, the mechanic and the masseuse, and all the other distributions, tens of millions of shares besides their personal shares. So it's interesting, but I think as to the looting, all the things I said about A would be the same. I think would be the same. And the fact that the GTII is so vigorously now engaged in legal proceedings is entertaining in a way. Is if they had expended the amount of energy they are doing in legal proceedings at this point, trying to move cases to federal court, trying to silence other voices, spending thousands of dollars. Obviously, I don't know who's funding that, by the way, and where the money's coming from. In fact, who's paying for the legal fees of the counsel for GTII? Who's paying? And where do those funds come from? Because if they come from shares that have been, and I don't know if this is true, so I'm just throwing this out. I'm asking more questions. Are they funds coming from illicit means? I mean, we talked about money in the complaint in Nevada. There's issues about $2 million apparently, and other settlement monies. There's an issue about apparently $4 million regarding operating. So where the funds come to pay counsel, or alternatively, if it's stock, is it valid stock? Is it our stock? Was it misappropriated? What happened to it? Is it proper? I'm sure counsel will answer that to the court at some point in time, and if not, I'm sure I will raise that issue again down the road. So I just kind of gave you two examples of things they allege I said, and in the complaint, where in the Nevada complaint, it might address it. And the Nevada complaint's not going to be all inclusive of everything. So there's going to be other things. And like that, there's probably, we go to K, we go to M. M is what, about 15, 16? So there must be about 15 or 16 of those. So the fact of whether it's true or not, kind of what I was discussing, is one element of proving a case for defamation. So defamation is you make a false statement with intent that causes harm. And so what's important is the statement false? First of all, if it's opinion, most opinions not actionable. If it's not opinion, is a statement false, or is it conditional? A lot of the stuff you'll see is also conditional. If it is false, is it per se liability, or do they have to prove damages? Per se liability for certain types of claims of misconduct. Damages are presumed, and you don't have to prove up damages, although to get real damages you would. So we've done, you make the statement has to be false. Does it harm somebody? And that's the other point. So does it harm somebody's reputation? So in defamation, I had one case. I thought this was a funny case. I had one case once we went to trial on in Los Angeles. It was a defamation case. I represented the defendant. It happened, ironically, within another case, but it was completely unrelated to the other case. So because there's a litigation privilege, which we may find out about a little bit later on, but there's a litigation privilege that says that anything that happens within and this is in California, it's pretty broad. Anything that happens within an ongoing case, as long as it's related to the litigation, absolutely privileged. So it encourages people to be, open and forthright in litigation. It also stops people from, suing everybody in a case. So, you hear somebody, you didn't like their testimony, so you sue them. So they thought, bad idea. So, so there's a litigation privilege that applies to anything that's said. And in that particular case, there was a deposition, and theoretically everything should have been privileged, but the defendant said something that was not within the litigation. So let's say the litigation, because this really was it. The litigation was about a dissolution. There was a partnership dispute about property in the Hollywood Hills. They were partners for a long time in a bunch of projects. They did not get along anymore. They couldn't figure out a way of selling the property, so it had to go into court. During that trial, during that case, there was a deposition. During the deposition, one of the parties accused the other of rape in their house. Had nothing to do with the case, so there was no litigation privilege that applied. So the case went forward. It got arbitrated, and in that kind of arbitration, even if at the end you had an option to not accept the arbitration award and move forward. So we arbitrated it. It wasn't cheap. We arbitrated, and I don't remember the number. And my client was a defendant in this case, and she believed what she said. It had happened 10 years prior, but there was no evidence. Made it a hard case. So we went forward. We had an arbitration. They got a result. It was a pretty mediocre result for them. I think it was on the order of, let's say, $10,000. Two specific claims. One she made in the deposition, and one she called the guy's partner thereafter. And the case went to court. It was a jury trial. It was about a week jury trial. And in the end, the issue that I raised, besides the fact that my client believed the story, was that this guy was a scumbag. And there was evidence of it. He had like a sex room in his house, whatever, and he was about 75 years old. So it was very humorous, the trial itself. But my pitch was, even if it's not true, my client believed it, so it wasn't malicious, and he was a scumbag. So what kind of damage to his reputation could he suffer, even if it wasn't true? And the jury deliberated long enough probably to pick a juror, and came back with a verdict for him on the 2 counts, and they gave him $2,000 on each count. I guarantee he spent well over, and this is a long time ago, he spent well over $100,000 in legal fees to get that. But the issue was reputation. So here we go, bringing it back to GTII. So if there's allegations that someone's reputation has been harmed, they have to have a good reputation to start off with. And that would be an interesting scenario to follow if these cases go forward, because if they could prove, for example, I said something defamatory to recover any significant amount of damages, they're going to have to show that GTII's reputation or Mr. Reichman's reputation have been harmed. And I probably did nothing to harm their reputation as it existed when I first started this in February of this year. I think they own their own reputation at this point in time. But that's how you would look at it. So it's the statement. It's got to be false. There has to be intent. You have to show damages unless it's a per se violation. And obviously it has to be causation. And you have to have harm to your reputation. So that's what they have to prove That's their primary claim. What I just have dealt with is kind of the truth issue. There are a bunch of legal issues that will apply to this that I will discuss. And they're going to be linked. So the Nevada case, the receiver case, TRO, and my case in some fashion will be linked because some of the information would carry over. So some of the information, if true in the Nevada case, would be very relevant in my case as it goes. But there are several layers of procedural matters that we're going to discuss probably soon as I am waved in and we can discuss. But that's kind of where it brings today. So I'm going to summarize. I'm bringing it all back to speed. So the case was filed on the 27th of June. The request for receiver and a TRO has been filed. A judge was passed on. It's called a peremptory challenge. One judge, the other side did the same thing. They tried to move the case to federal court. There's now been a request to bring it back to state court. If they don't agree today to that, then there'll be some filing which will try to remove it from federal court back to state court. This is all going to happen within days, not longer. When we get a determination about that, I will keep you apprised. There will be another hearing either in state or federal court about the receivership and about the TRO. And I don't think that will happen in the long term. I think that will happen in the short term, and we'll report on that. Apart from that, I think I told you with the other side that I agreed to waive service. They had to do something with the summons. They will be amending the summons, or have amended the summons. They will be sending me the documents so I can waive. It'll be filed. They won't have to physically serve me. And then I will have 60 days to respond. I will have a very interesting response, and we will go through it in depth when the time comes. Not yet. What I'm trying to do is to keep you apprised of what's going on, but I can't give you advanced strategies. But once something happens, I can talk about why and when. And why do people, for example, get rid of judges? They may do it for lots of reasons. They may prefer a different judge. They may not know a judge, or they may be trying to delay. So I'm sure that in terms of the action that we filed, the first judge was not affidavitted because of delay. That was not the intention, and that did not happen. But what the defendants did before they tried to remove the case to federal court may have been for the purpose of delay. And I'm going to speculating, but it wouldn't shock me. Wouldn't shock me they're trying to buy time. Why are they trying to buy time? Because they hope that things will change. Sometimes maybe they have something going on in the background. Part of when we got started here, we being all of us, the hope was to get these guys to do something. And I said, I don't care. I don't care if I bang my head against the wall and the legal stuff doesn't work, but it gets them to work as they should. That's fine with me. So whatever I can get them to do in the meantime, that's correct and beneficial, that's wonderful. And if there's something they need to do to complete now, that's helpful, and that's why they're trying to buy time, then so be it. I don't think it changes whether they should be off or not. But if it benefits shareholders, then why not? Why would I be against it? So anything that happens in the meantime, that includes, getting rid of the auditor. Now, the fact is that the current CEO is in an interesting position with respect to those shares that he had to cancel, because who issued those shares? I think it's the prior board. I think it included Mr. Reichman. If they were issued erroneously or inadvertently, that's an interesting position for the COO to be in, whether he retains those people, because the motivation is really key. But I don't know if they've thought about that. I also don't know, and it occurred to me also, is the new CEO who's been around apparently by their filing since December 1 of 2023. So it was about 7 months before he canceled those shares. If he was going to be a COO, I would expect him to have become familiar with the financials and the stock portfolio of the company. And if that was the case from the start in December of 2023, He should have been familiar with the issues regarding the distribution of stock, who did, and the financial status of the company, including who the auditor was, what the losses were, etc. That should have shocked and dismayed him. And I was shocked that he stayed, honestly. I was surprised that he stayed. But I presume he must have been aware. I don't know why it took 7 months for them to cancel the shares. I don't know because they indicated they were erroneously and inadvertently issued. That's not my language. So I don't know why it took them so long to do that in the first place. I don't know why they didn't do it to all the shares. Because if you remember, there's almost, I think, like nearly 70 million shares that were issued then. So why cancel some and not the others? Were they sold? What happened to them? Where'd they go? What's the explanation why they were issued in the first place? And was it erroneously or inadvertent? Which one? Because they're both different. Erroneously means that's somebody had made a mistake. Inadvertently, again, is like there's a machine and somebody's elbow accidentally hit the machine, and inadvertently 70 million shares were issued. I don't know which one is, but if the CEO was there and he was paying attention, I would expect him to know all this information. And I don't know why, if he did and it took this long to act, that concerns me. If he didn't know that information, that concerns me. And beyond that, we all know that, and this is just the truth, the CEO was both the CEO, the CFO, so the chief financial officer, and the chief accounting officer at the time that Borgers is that auditing firm that got squashed by the SEC, out of business in May, and that subsequent to that was terminated by GTII. But the CEO was both the CEO, the CFO, and the chief accounting officer when that scam outfit Borgers was there. And recall that Borgers prepared both the 2022 and the 2023 financials. And I would think, if there's errors or issues with those, and the CEO, CFO, and chief accounting officer chose Borgers, probably should have been working with them, at least supervising them. If there's problems, I think there's problems that go around to others besides Borgers. But that was blatant. And I don't know why it took them so long to get rid of them, because I'm aware of, for example, in MMTLP, and I bet you there's a bunch of other companies that use Borgers. Plenty of companies didn't wait till after the SEC squashed them. Again, I don't know why they waited, what the arrangement was, what they were paid. I saw concern expressed at some point in time in the PR, leaving the right to go after Borgers' fees and then perhaps pursuing them for relief. But if they pursue Borgers, don't they have to? And this is just a question. Don't they have to pursue the CFO, chief accounting officer, and CFO and CEO? And if the COO was hired by that person, isn't that a conflict? How does that person make that decision? And if there's a conflict, isn't that not in the best interest of shareholders? I mean, just a lot of questions that, a lot of questions. And, the date of the COO's current hiring was the date reflected by GTI management, which was that December 1 date. And again, 7 months. This is not like IBM to go through the financials and the stock portfolio. I mean, that's like a day, right? And after that, you should know what's going on. So it's nice when you do the right thing. It's hard and confusing when it takes that long. A lot of questions. And again, a lot of questions that I've presented before that have not been answered. That's kind of why we are having this discussion. So with that in mind, I'm going to leave it as is. And what I'm going to kind of do is every time there's like events, I will do live as opposed to video. That seems to be a better way, and I can just kind of blabber on for a while. And if my good eye sees any question, I will let it know. I don't think this is going to drag out. I think there'll be a decision in terms of the receivership and injunction quickly. So the lawsuit itself for the return of shares, money, that could drag out. But in terms of control over the company, I don't think that's going to drag out. I think that the company has an interest. Most litigation defendant likes to drag things out. So would this defendant be any different? Who knows, but probably not. So in their interest, they would like to drag it out. But that's not the issue. The issue that the primary issue that we're working on is getting rid of management and taking over control. And I think they've given enough cause of concern, and we'll let a court decide. If the court decides that there's enough here, they will grant us the relief. I think there's plenty here, and when they take action, like it seems like when they delay, that gives you more concern and gives you more reason to want to make the change, in my mind. Because again, they haven't filed the 10Q. Maybe that's the reason, by the way. Maybe they're delaying because they want to have the 10Q filed, but they also said they needed to audit the financials because of Borgers. So that's interesting. I don't think they could do both at the same time. So it's interesting to me what they're doing. Also interesting to me, again, who's paying the fees. So is it somebody connected with the company? Is it the company itself? Is it the CEO? If it's a CEO, we still have the same concerns based upon what that complaint said about the $2 million. What the other issue was about $4 million. Those are concerns. Those are valid concerns that have not been explained, despite being questioned. I'm going to assert the question again. I know that somebody at GTII is watching. Explain the cash, please. I've asked you many times. You just failed to answer. So I'm making it again. I know you watched this because you've cited it in the allegations against me. So you watch it. So explain. I think that's the problem, is if you would explain a lot of the details that we raised, if they're innocuous events, if all these can be explained, then why didn't you explain them? If you didn't explain them and you had the information, what's the logic in that? So most people believe, and I follow this, that if you're asked tough questions and you elect to not respond, that suggests there's something there. And that's what most people would conclude. And I think that's a reasonable conclusion. So I invite you, go back and look at all my emails. And if you start responding to my emails, I'll do another live and give your response to the emails too. So I welcome you doing that. Try to be upfront and direct and honest at all points. And again, my intention at all was for the benefit of GTII and its shareholders. I don't believe that with the current management, we can make a go of it to have all these people recoup their money. And that is why I'm here. That's the only reason. And again, obviously, this is not legal advice, obviously, and it's clearly not financial advice. Anybody who takes financial advice from me should have their head examined. Anyway, so that's a summary of where we are today. And again, I expect events to happen quickly. And as they happen, I will do lives. It may be short, brief, but I'll bring you up to date. So when I find out next big step will be whether we're in state or federal court. When I find out about that, I'll do a live. As I mentioned, that when there's a hearing for receivership and an injunction, I will be in attendance and I'll report to you live. And again, as we go, we will do it. And as to the complaint against me, again, part of my journey here, my interest is to kind of explain things so non-lawyers can figure out what's going on. So if you have encounters in the future with lawyers, it'll be easier for you. And I think I have a reasonable skill set to explain this nonsense, as I call it. So what I'm going to do as we go through the complaint against me, I'm going to try to explain thinking after an event has happened. And so it makes sense, hopefully. And so you'll get an idea of how it goes procedurally also. You know that a complaint was filed. You know that I've waived service. And we'll kind of go through the scenario so that if you're ever involved in an action yourself, you kind of have a better understanding of how the flow will go. And for most people, it's pretty freaky. They don't like being, nobody likes getting sued, obviously. But if you haven't been sued before and you get sued, it's quite frightening for most people. So maybe this will demystify it a little bit. You'll kind of understand it. We'll kind of go through the thought processes. Everything's public, so we can talk about it publicly. I'm not going to obviously tell you something I'm going to do that I think is going to harm my position. But again, I will tell you afterwards what my thinking was and what we'll do. And so from this point forward, waiting for the waiver. After the waiver, I'll have a whole bunch of activities scheduled, and we can kind of go through them. You can learn the law, and it will relate to use of social media. So I think for a lot of people, it'll be relevant. Maybe it'll give you um, some comfort knowing what you can and cannot do. Obviously, we have seen now that anybody can sue anybody for anything in America, and California happens to be like above and beyond the call of duty. So there, surprisingly, there's a lot of litigation in California. But you know now that somebody can get sued for their statements made on social media, whether it be in a video or on X, because I think there's some allegations about X in a writing, that anybody can be sued. And um, for a lot of people, it's an issue of practicality. Money, how much you're going to pay in legal fees? Are they going to try to shut you up? And it's a big problem because most people either don't have the ability to pay or don't want to pay. Who wants to incur a bunch of legal fees? In my case, obviously, although there will be counsel involved for a strategic reason, and when we get there, I'll discuss that because that's a good name. But for most of this stuff, I can do on my own. I probably would have somebody at trial who would be kind of questioning me because that will appear better. But everything else, other than a section which we will talk about later, I can do, and I can kind of give you my thought process on it, and I will kind of go through it in terms of discovery. We went through this with MMTLP because we were stuck going through arbitration. Here we have a civil action, and we can kind of be open about it, and the pleadings are open, and discovery will be open, and I think that would be interesting. I think I'd be interested in finding out, if we get to that point in time, what the documents at GTII show. And theoretically, both in Nevada action and in my action, I will have the right to get discovery, which means I'll put out a document request. So they made certain claims. So now I'm going to make a document request. Document request will ask for all documents they have to support their, and I'm summarizing, all documents to support their claims, all documents to support their damages. And then I'll get access to that. I've also I asked this in the past. I can have access to their books and records. I made that request before. So are they going to be anxiously looking forward to providing me access to all their financial records? I don't know. That may not be something they're anxious in doing, but to establish damages to some degree, that will be. The lifestyle of Mr. Reichman and how he's perceived in the atmosphere, whether he's a public figure. What's the significance of whether he's a public figure? If someone's a public figure, when you have defamation action, you have to prove up malice. If it's not a non-public figure, you don't have to prove up malice. So that someone maliciously intended to harm someone else. Obviously, that's not wasn't my intention, even though everything I said was true. But it certainly wasn't my intention. And David would have to be, I think, a public figure, which would require malice. So those kind of things we will go through, and we're going to learn defamation and trade libel as we go through this. So you'll have an understanding of that. And again, hopefully, it'll give you some better understanding of your protections when you're using the internet, what the downfalls are, and what companies might do to protect their own skin, why they act as such, and here in this particular matter, what these guys are, why are they spending so much money on legal here? What's the motivating factor? It's confusing. It's not Tesla. We're not talking about Tesla here. So the company has $0 in revenue, producing zero. This is not like even $1, zero. 2022, 2023, as far as I know, into 2024. $0. So based upon that, based upon the fact, and if somebody has a different understanding, please tell me what deal is about to close, what transaction is in mode, what is going on. So what future revenue is coming forward? Anybody, please tell me. Anybody have a hint? Because if there is, then that would make sense too. But if there's no transaction, if there's no revenue, then why are these guys spending thousands of dollars in legal fees? What are they spending it for? What would you think if someone told you that? If you didn't know who these guys were involved and somebody told you that, somebody accused somebody of being involved in the shenanigans and they don't have any money, but now they're spending thousands of dollars protecting their interest. Why do you think they're doing that? I'm going to let you conclude that. I think I've already concluded my own. I think it's self-evident that it just sounds wrong, sounds spotty, sounds like something is amiss, and again, could have been explained away. Opportunity has existed for them just to answer questions, respond to emails, come out publicly. I'd invite them on my live stream. I think I already did, but I'd do it again. Come on down, explain it. Again, if there's an explanation, then that's great. I really have no interest in anybody suffering anything if it's not true. But if again, I'm just last statement. If someone accuses you of doing something and you clearly are appalled by the accusation and deem the accusation false, and they request you to respond and you don't, most people will conclude that the accusation is true. And that's just human nature. And I think that's just logical, because otherwise, you have the opportunity. That's kind of America too. You have the opportunity to respond. You don't respond, then so be it. So I've kind of like, I don't know how many times I could say that. I've killed that point. Anyway, I appreciate everybody who watched. Take care. I will keep everybody apprised, obviously. Again, I expect action on this daily, if not bi-daily or dual weekly, and we'll keep everybody apprised. And I'll try to do it live so everybody can kind of keep track and don't have to watch the video. By video, I'll post that too, so you can watch it if you want, and you can enjoy the skylight behind me. But anyway, everybody who stayed here, I appreciate it. Take care. Have a great day. Always appreciate you. If you have any comments, questions, please put them in the stream and afterwards, and I will try to get to everybody and try to give you an answer if I can. Anyway, take care, everybody. Take care and have a good day.